some limited ability to pay, award attorney fees in the amount of $2,000. That's the order of the court. I have prepared the order.
Your Honor, will you order that the husband continues to maintain all the insurance payments that he's maintained so far?
I've actually not in your order, except for the fact that I've just ordered that he can't change the entitlement of any insurance policies, etc.
It's been in controversy before, so I want to make sure it's clear.
Thank you, Your Honor. I've actually used your order. So.
Thank you.
Your Honor, can I clarify where the $2,000 for attorney's fees is to come from?
It is to come from his income. I have made the order. Thank you.
Thank you.
Thank you, Your Honor.
Security number 13, Ferrell and Ferrell, 1307929. Ready to please come forward?
And on the Rogers case, where's respondent? Is she not coming in?
I'm sorry. She just does not feel comfortable signing the order.
All right. Have her come in, and I'll make sure that she has a copy before she leaves, though. And Ms. Rogers, yes. I understand you do not want to sign this order?
Well, I was just making sure it's there.
It is actually the order, and all you're signing is that you received it, not that you agree with it. Okay, so I'm going to have you sign it, and then my clerk is going to give you a copy of it, okay? All right, thank you. Morning.
Good morning, Your Honor.
All right, and I've got to get to the right case here. This is the Ferrell matter, and the parties please identify themselves.
I'm Moira Ferrell, self-representing.
John Ferrell, self-representing.
All right, and I believe this is your motion, ma'am. I have read the papers.
Yes, thank you. My first comment is that my husband's response exceeds the page limit of 20 pages. He has given me a copy of his response that was a total of 25 pages, additional 9 pages of documented sworn statements, and I asked...
Well, I could tell, and I do not treat pro ses. I attempt not to treat pro ses any different than I treat attorneys, but if you're representing yourself, I really can't. I'm not allowed to. And I would tell you your papers are some of the worst papers I've seen, sir, because I got half pages of papers. I also got them double-sided. I got them in small font that my eyes are going bad. I can't read some of them. But I've read through them. I struggled through them all at this point. I'm going to consider them all. But when you both file papers, there are rules when you file papers, and you're going to be treated as an attorney when you file these papers. So make sure you follow the rules. If you have difficulty, go to Family Law Information Center. Talk to an attorney there so you don't have struggles with these rules, okay? All right. But I have read all the papers. I stayed up till 2 this morning reading these papers, so I am ready for your hearing.
Okay.
Thank you.
I filed a motion for temporary orders on 3 different specifics. One is to have John vacate our marital home. Secondly, for the court to accept my proposed parenting plan. And thirdly, to have a court order mandate that John pay child support and spousal maintenance. We've been married for 16 years. I have been the at-home mother to our 5 children and have homeschooled them for the last 9 years. I also manage the majority of our children's extracurricular activities, which includes their involvement in Boy Scouts, orchestra, piano lessons. Recently, my boys are now involved in a hunting certification class, and I often carpool for my son's Irish dance class. I have chosen our children's pediatricians and their dentist and have taken them to the majority of their appointments.
I've read all this in your papers.
Okay.
I don't need you to reread it.
I am the manager of the home in most categories of domestic order. Our marital tensions for the last 16 years have been unrelenting. We've worked with 6 marriage counselors to the effect of trying to resolve those problems. The last 2, most recently, Dr. Recknagel and Dr. McBride have provided letters.
I don't need the diagnosis. I've read it.
Okay. I have filed for divorce asking for reprieve, and John is not willing to negotiate any settlement or resolution to that divorce and has made excessive effort to delay, draw out, and prolong this process. Our court hearing is not for 5 more months. I expect that it will be torturous to remain living with John during that time. I am
And
asking
you're still in the same house right now?
we are currently still in the same house,
And how big is this house?
2,800 square feet.
And is it separated by different floors? Is one of you on one floor, one on the other? How's it
I'm
mean?
on one floor on one end of the house. John's bedroom is on the opposite end of the house. I homeschool the children. I'm home during the day, and John has a home office, so he's home during the day also.
What does the home office consist of?
It consists of about a 10 by 10 foot bedroom,
I'm talking about what stuff is in it
a
that,
computer, a desk, a set of files, a fax, and a phone. Most of John's appointments take him, most of his work takes him out of the house on appointments in the mornings. He uses his home office just as a communication base, and that could be relocated conveniently to any other location. He's had 3 different locations he's worked from in the business of Ferrell Apparel for the last 9 years.
I object to that.
what's your objection?
It would be very disruptive to move the business.
Okay, that's not an objection. She's making an argument. You get to have your chance after she's done.
Okay.
John has cut me off financially. Since August of 2011, he closed all of our bank accounts and removed my name from them. 4 months later, when I was instructed that this was abusive and reported this to John, he reinstated an American Express to me for a limit of $1,000 monthly. Most places don't take American Express. I can buy gas and groceries. Despite his control of the funds, he continues to spend lavishly on things that are for himself.
All right, I need to know more at this hearing. You have to understand I've read everything in this stack right here.
Okay, I understood. I was just to repeat that to you.
So I don't need repeated. What I need to know is you have indicated he makes X amount of money.
Mm-hmm.
And your basis for doing that is you went through all the bank records and you came and you spelled all those bank records out, and this is the money he's made. He's indicated in his taxes he makes X amount of money and significantly less. I want to know what the difference between the two of you is. That's it. I don't need to know everything that's in the paper. I want to know why your position is right, and he's going to tell me why his position is right.
Mine is documented with bank statements.
Anything else?
No.
Sir.
I would, Your Honor, petition that we move for a continuance for 3 weeks on this case to give me more time to do any legal research and financial paper.
Denied.
Okay.
The reason I deny it is she prepared her papers. You responded to the papers. There was no request for a continuance. She did a strict reply. We came here. We spent all this time and effort, and we're going to hear this today. And also, delaying this 3 weeks doesn't seem like it's going to do either one of these parties any good. So we're going to address it today.
I asked her for continuance, but okay.
I'm going to ask the court for one. She doesn't grant continuance. I do.
I'm asking right now. You
Okay.
denied. Okay. To try to summarize what's going on, she's unhappy in the marriage. That's what she wants is a divorce. We're one big happy family. We work together. She just moved out of the big bed 2 or 3 months ago, and we get along fine. There's no danger. There's no abuse. My business is integral to staying in the house because there is all the inventory, which she also didn't mention, and all the UPS.
What's the inventory?
The suits. I'm a custom tailor, so there's all kinds of things in the office. The whole bedroom is full of Ferrell apparel. It's very disruptive to move it anywhere. We do just fine together in the house. The kids want us to stay married. Everything works just fine as it is, and I would submit that to try to break this up or do something or make a decision today would not be wise. I would petition that we have an evaluation done for our family with a social worker, a master's in social work, to help us find out what really is in the best interest of the children versus breaking this up, which I propose would not be. Our most recent counselor, Dr. Dillsaver, also has put his finger on what's going on, which is the root cause is selfishness. Moira does not and will not talk to him anymore. That's what we're hoping to try to have a happy ending and bring this together versus tearing it apart. Let's see. I have not cut her off financially. I've always provided. But when she was dealing with other men who were very interested in her, emails back and forth, all that good stuff. I naturally would take control of the family money versus having it be an open book. I never closed any of her accounts. Our joint accounts, which we both had control over, I took care of, and they're still there. But I've always provided, I take care of and pay for everything, and I've never denied her dollars, and I don't fight with her, and I've never raised my voice, all that good stuff. I don't know where to start because there's no reason for all this, but she's unhappy.
Again, in the state of Washington, under the laws of the state of Washington, she doesn't have to have a reason. She has to state the marriage are irretrievably broken. That's the end of it. She's saying that that's occurring. Now we have to deal with the financial aspects of it, the parenting plan aspects of it, and I need you to focus on that because nothing else I can deal with on the calendar. So let's deal with the financial aspects, the living aspects, and the parenting plan aspects of this.
Okay.
Go ahead.
I propose I live in the house, and if Moira is unhappy, that she go to work and get her own place to live, and she's an excellent mom and homeschool teacher, and I'd like her to stay homeschooling the kids and can do that. We have proposed, if anything, that we do a tag team parenting plan, which keeps our house together, keeps it integral with the family and least disruptive to the kids. We all get along fine. Everyone wants a happy family. So that's my proposal, that she move out because she is unhappy, which is unfortunate, and we continue to keep the family business together and stay in the house, and she can stay here during the day, and I stay with the kids at night. Because there are times when she stays out all night and won't answer her phone, and it's just not good. But during the day, I think she's fine. That's what I propose.
Still haven't got to the finances. I went through the same bank record she did, and I came to the same conclusions as she did. You say one thing on your taxes, but your bank records are substantially different than your taxes. And
right.
Like I said, this is the one I spent over 2.5 hours going through these records last night, trying to figure out what's going on. And money going into your account was over $300,000, and your taxes don't tell me that.
That's true. I own the cash register. There's people giving me money every day for deposits on suits, and that money piles up. I have a permanent loan available to me by using that money. It's not income. It's
not income for accounting purposes, is what you're telling me.
That's right. It's money that I can use. It's temporary deposits. And I always have hands giving me more money for deposits on suits, so I have use of that dollars. I talked to several CPAs, and they told me this is called a hybrid cash flow, or hybrid cash basis, so that you count everything as it's pictured, but your cash flow, if it's deposits, is not counted as income until it actually is a completed sale. So I complete X amount of sales in the year, and that's my gross income. The rest of it is, again, it's just cash flow dollars, and we're able to utilize them, but it's not income. So when it's called stealing from yourself. When you own the family restaurant, you can take food from it sometimes if you put it back. I have constant loans coming to me in deposits. So half of our existence is borrowed money. It's not income. And I've been consistent with this accounting since day one, and I've checked it out with different CPAs who have told me that. That's one of the things I would want to get more work done to explain. But I was rushed. I'm sorry, the paperwork wasn't good. I did everything I could to get all this together. Speaking of, I also have 5 testimonials stating that Moira is not the more fit parent and that I should be the one to be in charge of the kids. Specifically, her mother-in-law, I imagine you read that, or my mother-in-law, and close friends who have known us for years have all said John is the more fit parent and should be the one to take care of things. So my income is what it says on the tax returns, and that's what I suggest we use to base any support. Ma'am?
Ma'am,
Yes, thank
do
you.
you have a brief reply?
Yes. I've never spent any money on other men. That's an absolutely unjustified claim. I would contend that the emotional tension in the house is unbearable to me, and the thought of enduring for 5 more months till final orders can be resolved is unacceptable. If John requests that I go to work, it is a conflict that I would remain also homeschooling the children for the bulk of the hours of the day. I don't see how the two are compatible. In regards to the finances, John makes comments that the merchant deposits in his account are loan. They're not loan. They're payments from customers for goods purchased. The only other issue in his deposits to be asked about are the checks which are unidentified in their source. I could not get those checks from the bank because my name is no longer on those accounts. John has chosen not to research and look into those checks to confirm that they were, in fact, payments from customers. John's primary basis for calling me an unfit parent in his response was that he said I was suicidal. That is totally unfounded, and if I'm not suicidal, then I am a totally fit parent. He just said today that I'm an excellent mother and educator.
Thank you. What area you live in right now?
Mercer Island.
Find a lot of jails in Mercer Island. Right. You can write this down if you desire, but I have done the final temporary orders in this matter. I will deal with the parenting plan at first. First of all, upon reading all the papers, and I went through it, I do not find the father to be believable, and also based on your testimony here, I just don't find you to be believable. I don't think that you were involved in children's lives as much as you'd like to think, and also I did consider your criminal history. I considered everything in this case. As such, I am not going to put any current restrictions on either parent. What I'm going to do is reserve those restrictions. I find that the mother has been the primary parent, and she'll continue to be the primary parent. Until the father has a suitable home for the children to sleep in, his visits will be every Saturday from 9 a.m. to 6 p.m. Once he has suitable arrangements, the visitation will be Friday at 5 p.m. to Sunday at 6, and every week that's every other weekend. And then during the weeks, he'll have every Wednesday from 5 to 8. Schedule for the winter vacation as per the mother's request. 3.4, the school breaks per the mother's request. Summer schedule, each party can have up to 2 weeks of summer visitation with the children. They need to give their intended dates by June 1st. Actually, I'm going to make that, since it's very close to June 1st, I'm going to make that June 15th. I have right now just alternated the holidays. Mother's Day with mother, Father's Day with father. The times for that is 9 a.m. to 6 p.m. I have reserved the issue of any restrictions. The transportation shall be done by the receiving parent. Petitioner is designated custodian for all other state and federal laws. Mother and father shall make day-to-day decisions when the children are with them. All major decisions are joint. I have taken out religious upbringing because that's a constitutional issue, and I don't rule on constitutional issues. I don't rule on religion issues. Dispute resolution is reserved. All other provisions are reserved. I have stricken all the requested other provisions because those are something for the trial court. That is the parenting plan. As to the temporary order, I have made the restraints mutual. Both parties are there actually was no requested restraints except for the petitioner respondent are restrained and enjoined from disturbing the peace of the other party. I have adopted, for purposes of this hearing and also based on my calculations, somewhat of the mother's worksheet. However, she didn't take out appropriate tax, etc. I have done so. The respondent shall pay $3,500 per month spousal maintenance starting May 1, 2012. I will get to the child support in a moment. Both parties are restrained and joined from transferring, moving, encumbering, concealing, or any way disposing of property. Both parties are restrained and joined from removing the children from the state of Washington. Both parties are restrained and joined from transferring, borrowing, lapsing, surrendering, and changing entitlement and insurance. Each party shall be immediately responsible for their own debts. The family home shall be occupied by the petitioner. The use of the property shall be as follows. The petitioner has the Ford Explorer. The respondent has the Cadillac. The father shall vacate the family home, and he can take the following. He could take his inventory, the computer, the desk, his files, his fax, everything in his office, and all of his personal belongings from the home. He needs to remove everything from the home by June 10th, no later than that. I'm going to make sure I write in what the father can take. Any disputed items, in other words, the father wants to take something that's disputed, that will remain in the home pending the trial. A guardian ad litem shall be appointed by separate order. The father shall pay the initial retainer for the guardian ad litem. That's the temporary order. As to the guardian ad litem, under RCW 2609 for dissolutions, I've appointed a guardian ad litem. Two of the children, Brianna and Liam, will need to sign a appropriate waiver if they choose to do so, the guardian ad litem can release the information because they're both over the age of 12. The fees for the guardian item can be redistributed by the trial court. I have appointed either David Hodges or Jack Mahler, the first one available. I've put their phone numbers on the order. The order of child support is as follows. I have found the father's monthly net income after reducing the maintenance, $76.86. The mother's net income, including maintenance, is $31.90. The total transfer payment for child support is $25.1840. I have not provided a deviation because there is no basis for deviation. This shall be paid through the support registry. Post-secondary educational is reserved to trial. This is until a subsequent order is entered. The periodic adjustments reserved to trial. Tax exemptions reserved to trial. And that's the order of the court. Any questions, ma'am?
No, Your Honor.
Any questions, sir?
Who pays the mortgage, and is this just temporary then? So how's it going to work?
She's going to have to pay the mortgage. That's why I give her the maintenance. Thank you. They should sign off on the orders I just gave them, and then the clerk will give you copies.
I'd like a copy of the order, yeah.
Yeah, go ahead, and she'll call you up when she needs each one of you.